The CC&Rs, that's the playbook for everything.
Yeah.
And that's where all the rights and obligations really derive from. And it's similar to playing Monopoly with a child. You know, they don't know the playbook and they're all over the board, and it just destroys the game. And that's very similar, right? There's certain things you can and cannot do, and it's no different than an association. And so when you have a bad board who's just ignoring the CC&Rs, your rights are going to be derived from the CC&R. So that's really the starting point. Take a look at the CC&Rs, understand where your rights are being violated. So for example, if it is a dispute with a common area, like they're failing to maintain a common area, or there's sort of negligence around a roof or certain elements within the community, you're going to be able to find that most likely in the CC&Rs. That puts the obligation on the board in the first place to maintain, repair, etc.
Sure.
So that's a very powerful step. It's an obvious step, but you know, I speak with a lot of homeowners who don't always start there. So that's a wonderful place to really start, frame out, okay, how is this game played? And then as you push forward, you're going to be that much more powerful. I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson of L.S. Carlson Law. We are a law firm operating in California and Florida, focusing exclusively on homeowners' rights against bad HOAs. We've been in the business for 17 years, and we have this podcast really to bring powerful information to homeowners who are experiencing bad HOAs. I also have Marty on the show. He is the producer. Welcome.
Hello. Thank you.
Thanks for being on again and joining us.
It's always a good time
as we go into the wild world of bad HOAs.
There's a lot of content there.
It's kind of endless. It's the gift that keeps giving. All right. So today, where would you like to start, Marty? I will let you take the lead and guide me.
Today's an interesting one. Obviously, we've done dozens of episodes at this point, and we've covered everything from dispute types, from neighbor disputes, selective enforcement, all the way down the gauntlet, as well as personality types of bad board members.
Right. That was fun.
Tyrants, meddlers, incompetent. But I think this one's interesting, though, because a lot of the content within those episodes, we cover, okay, now what? We've had a dispute. You've encountered these people. Now what do you do? So I thought it would be interesting to take a lot of that guidance is similar. And I think it would be really interesting for the listeners on the other end to get a snapshot on, the 6 steps that you would take, or the guidance that you would give as an HOA attorney with this much experience. What would the steps that you would take, or the steps that you would guide a homeowner to take should they have an HOA dispute and they want to try to resolve it as effectively as possible without having to deal with bringing on an attorney or without legal intervention? So I'd like to go through those 6 steps. Just going through this over the past, year or whatever we've been doing this, I think it's chock full of good information. I think it's a good starting point that if anyone hasn't listened to the podcast, this is the starting point. And then, should they want to dive in deeper, we have all the episodes that they can dive into.
So a true self-help episode. Regardless of type of dispute, there is a dispute. What does a homeowner do without a lawyer? Because in my mind, that's always a win. If you can get something resolved without a lawyer, that's a win.
Certainly.
So, okay, let's jump in. I like that.
Okay, so the first one is document the issues. Emails, pictures, videos, notes, etc.
Okay, so yeah, that's really the starting point, because at some point in time, your life is great, you're living in an association and it's working, and then it's not. And typically things, when they turn, it's very obvious. There's some sort of damage to the property, or there's some form of harassment. So the first thing you want to do when it first originates is to document. And that might just be creating a file for emails that you're getting. Maybe they're harassing emails. Maybe there's harassing letters that you're receiving, or even there's actual physical damage to the property because of some sort of negligent activity of the association.
Or drainage issue.
Yeah,
or
so
something.
maybe a common area pipe broke and your place is getting flooded.
Yeah.
Video it, take pictures of it, whatever you can do to document at the outset. And as the dispute continues, the better.
Yeah.
It's going to put you in a more powerful position once you do elect to enforce your rights. And whether that enforcement is hopefully through self-help, but if it comes to bringing on a lawyer or an advocate, you're going to be very well heeled in that pursuit.
Yeah.
So yes, document everything.
Yeah, that's great. Number 2, read your CC&Rs. One thing I've really come to find out through doing this is 9 times out of 10, it seems, correct me if I'm wrong, that it's the HOA that is breaking their own CC&Rs, and that's the reason that you have some sort of you can come to some sort of resolution, because it's the HOA that's actually breaking the rules.
Yeah.
Which is interesting. But read your CC&Rs, and I think to that extent, you got to figure out what rule either they're violating or the rule that you're being accused of violating.
Yeah. So if you take it back a little bit, the CC&Rs, that's the playbook for everything.
Yeah.
And that's where all the rights and obligations really derive from. And it's similar to playing Monopoly with a child. They don't know the playbook and they're all over the board, and it just destroys the game. And that's very similar, right? There's certain things you can and cannot do, and it's no different than an association. And so when you have a bad board who's just ignoring the CC&Rs, your rights are going to be derived from the CC&R. So that's really the starting point. Take a look at the CC&Rs, understand where your rights are being violated. So for example, if it is a dispute with a common area, like they're failing to maintain a common area, or there's sort of negligence around a roof or certain elements within the community, you're going to be able to find that most likely in the CC&Rs. That puts the obligation on the board in the first place to maintain, repair, etc.
Sure.
So that's a very powerful step. It's an obvious step, but I speak with a lot of homeowners who don't always start there. So that's a wonderful place to really start. Frame out, okay, how is this game played? And then as you push forward, you're going to be that much more powerful.
And I would assume too, as you're taking notes and documenting, you should say, okay, well, this is in my CC&Rs. This is the rule number whatever in section whatever. This is the one that they're violating, and
Precisely.
It's nice to have that documentation.
And
as
it just
well.
gives clarity. You're clarifying what the board is supposed to be doing, what you're supposed to be doing as homeowner.
Sure.
And so when you eventually do bring it to the table, you are elevated in that approach.
I think it's worth mentioning, and we'll just gloss this real quick too. Laws are changing frequently. We've seen it in Florida over this past year. There's a lot of laws that are changing. And without getting too much in the weeds, it's possible that your CC&Rs are no longer within the realms of the law too, right?
Yeah. So I obviously am a California lawyer, so I speak to California law.
Yeah.
But as the laws change, and your CC&Rs become antiquated, that becomes an interesting balance, right? And, the assessment, the majority of the time is that, state law is going to supersede the CC&Rs.
Sure. Federal, state, local CC&Rs.
Correct. And so that is somewhat of a more elevated analysis that has to happen.
Yeah.
I wouldn't expect a homeowner to, sort of jump into the different codes and keep updated with all the different changes in the law. But it is something to be mindful of.
Yeah.
I mean, that was a big one with the drought restrictions in California.
Sure.
And a lot of the CC&Rs, many ran in a very inconsistent manner, of course, because they didn't change as quickly as the laws were changing during the drought periods. And so that was a huge point of friction amongst homeowners and associations. And typically the homeowner was in the right. They convert.
And you're speaking about like drought tolerant landscapes.
Correct.
And your CC&R say you have to have X, Y, Z, but the laws are saying that you can have this. Yeah.
And eventually the homeowners won on that.
Sure.
Even though many associations fought it tooth and nail. And if you go back to some of our previous episodes, it often was the incompetent type that was driving that.
Yeah.
The board members who just didn't understand the difference, the balancing act between the two, enforcing the CC&Rs, notwithstanding massive changes in state law.
Yeah, I mean, we in California, I mean, we're going through a lot of changes in because of the housing crisis. Where the ADUs.
Oh, that's
There's
a very hot topic.
solar is
Solar
another
is
one.
popping. And what homeowners need to realize is they have tremendous rights under existing law.
Yeah.
And those laws might be inconsistent with the CC&Rs, but then it's just a form of how do you enforce, how do you prosecute to your advantage.
Yeah. So even if it's outlined in your CC&Rs, if a new law has come about, you still might have rights. So
Correct.
you should do your due diligence. And if you are going to bring it to an attorney or eventually get it to that point, it may as well do a little bit of homework to see if there's some.
You might as well, not to a point where you get frustrated,
Of course.
but to a point where if you do end up sitting down with an attorney, you are informed.
Sure.
And a large part of the attorney's job is to make sure that they're current on the law. They understand what laws might have changed that impacted your rights.
Yeah.
But yes, any sort of homework that you can do is always or should be embraced by a lawyer.
Sure. All right. Let's go to the next one. Okay, this is if applicable. Request records. I think we talked about this in our selective enforcement episodes of request records for fines that are possibly levied. If they're accusing you of something, and the neighbor's doing it, or the other neighbor down the street is doing it, and you're being targeted, possibly request records of fines that are levied. Make sure that you're not the only one that have been.
That becomes interesting.
enforced.
Often I recommend a homeowner do their own due diligence.
Sure.
And sometimes it's very easy. I mean, sometimes a board won't turn over certain records,
Yeah.
and that becomes its own legal issue, which can be handled with separately. But a very easy low-hanging fruit is talk to your neighbors. You might have a neighbor who has the exact same situation that you do, and you turn out that you're the only one receiving notices.
Yeah. And then document.
What's that?
Go back to your document it.
Correct.
If
Yes.
your neighbor says X, write it down.
Correct.
Or even better, ask them via email or summarize it via email. And then they can go back to the neighbor and say, yes, this is true.
Precisely. And then that's where you might get into a selective enforcement issue, a preferential treatment, but knowledge is power. It's a cliche, but it is very true in this space.
I think there's a few other aspects, though, to requesting records, like negligence. Request the repair bills or inspections or common area disputes, maintenance records.
Yeah,
You have a right, if I'm not mistaken, don't you have a right as a homeowner to request these records? I mean, you are part of this community.
You do. So the code allows for the homeowner to make a demand on the board for very specific records. There's a very long section on it, but yes, that is a very powerful tool to demand a board turn over certain records. And to the extent that they do not, there's certain penalties associated with that failure. So that is a very powerful weapon to sort of force the association to be transparent, which they should be in the first place.
Yeah.
And, if you look at a well-functioning association, typically you shouldn't have to jump through a bunch of legal hoops for information.
Yeah.
Because why? There's a high level of transparency. If you really read the Davis-Sterling Act, much of the Davis-Sterling Act or the spirit of that act is transparency.
And the Davis-Sterling Act is in California. That's
Correct.
Very specific laws for
Precisely.
Homeowner associations.
Yeah, it's the governing. If you look at the umbrella law over associations, it's Davis-Sterling.
Yeah.
And that law really is or embodies the spirit of transparency.
Yeah.
Because a well-functioning board should be transparent. Why not? What do they have to hide? So the friction points start to arise where they don't want to be transparent. A bad HOA doesn't want to turn over information. Why? Because it might be incriminating. So maybe better to put up a fight. So that could be a red flag as well. I mean, if you're a homeowner and you're entitled to certain records and they're refusing or they're stonewalling you, that is typically a red flag or, where there's smoke, there's fire type of situation.
What's the best way of requesting those records, in your opinion?
You typically make a demand directly to the board.
Do you via email, phone call,
email,
in person?
Always in writing.
Always in writing.
Whenever you're demanding anything from the board, and we're going to get into IDR in a moment, but anytime you make a formal demand on the board, always do it in writing. And it's interesting. I mean, you get into situations where you'll show up at a board meeting and you'll request certain information verbally.
Yeah.
And whether it's in person or over Zoom,
Yeah.
you'll request it. But it's never a bad idea to do a follow-up email.
That's a great tip, actually. Just to I don't know, not enforce it, but like to make sure that there's a
memorialize
document. To
it.
memorialize. That's the word I was looking for.
Yeah, because if it's an open session, you don't want to rely upon someone keeping minutes.
Yeah.
Or their clerk. 'Cause typically they have someone, the secretary who's taking notes of the meeting, but you don't want to rely upon that.
Yeah, or worse, hearsay. No one takes notes, and it's my
Correct.
word versus theirs.
Exactly. So
If
always follow up. Say, it was. You can always be positive about it. Say it was a very nice meeting with everyone on this date at the open meeting. Again, here is my request. Please advise.
Yeah.
And maybe they made mention. Maybe they said, "Hey, we'll get back to you within 5 business days."
Yeah.
Memorialize that. Anything that was meaningful, substantive. If it was verbal, fine. It can be verbal. Put it in writing afterwards.
Sure. Yeah, that's a pro tip right there, just to make sure that you've got it documented.
Right. Which goes back to the first tip, which is document everything, right?
I mean, a lot of these kind of have a through line.
Yes, they do.
Okay. If applicable, again, get third-party parties to assess damages or the determination of cause of a particular issue. So this is hot, I guess, in like a condo with there's common areas of like a roof, and the association has neglected to maintain said roof, and it caused a bunch of problems. Or there's a neighbor that has a pipe, and it burst, and it's now taking care of you, or it's now causing damage in your unit. There's a lot of different issues potentially here.
Yeah, and this goes back to documenting, but having a third party verify and produce some sort of report can be very helpful.
Yeah.
Now, with certain situations, when you're dealing with a common area, your expert may not have permission or authority or the legal right to access certain common areas.
Oh, sure. Yeah.
Right? Often your expert that you hire, the roofer, may not be able to go up on the roof.
Mhm.
It's common area. It's not permitted. But at the end of the day, to have an expert come in and at least assess damage.
Yeah.
To say, hey, you know what? If we were to put this back to its original condition, it's going to cost $50,000, $100,000. And based upon what I can observe legally, this appears to be the source.
Yeah.
That can be very helpful information.
Yeah.
Now, the one thing, not to get too legal or too nuanced on this, is you have to realize when you do get a report, when an expert does come in, let's say worst case it turns into a lawsuit, it develops into full-blown litigation, that report might be discoverable. It's not protected. Meaning, if that report comes back negative or not in your favor, that could also be used against you in some way.
Interesting.
So you have to be careful with expert reports because, listen, the last thing you want to do is you don't want to hire an expert who's not credentialed or who isn't a true expert, come in, misdiagnose the situation, give you a faulty report, and all of a sudden that faulty report is used against you, notwithstanding the fact that if you had a real good expert come in, they would have, sided with you.
Yeah.
So you have to be careful with the experts.
Sure. But even so, when it gets down to, if there's a lawsuit filed, they need to assess what the damages are, what you're seeking, right? And this is where the expert comes in.
And a good litigator and a good attorney will do it in such a way where any report is protected by the attorney-client privilege.
Oh, interesting.
And it gives you somewhat of a safe harbor to operate in.
Interesting.
So just small pro tip there, but just be mindful of who you hire.
Sure.
And if you're going to go that path, make sure it's absolutely reputable and credentialed.
Interesting. Okay, let's move to the next one. Informal resolution. Try to do it peacefully.
This is the olive branch.
Yeah, this is the olive branch before you ramp it up. So you've documented, you've gone through your CC&Rs, you've got a case here, you've had your experts, you've requested records. Now it's time to try to resolve this with the board and try to do it I can't even say the word. Amicably?
Yes.
Yeah, a tongue twister.
It is. But yeah, it is the olive branch approach. And, sort of going back to the Davis-Sterling Act, again, transparency is very important. That's the spirit, I would say, of the Davis-Sterling Act in the first place. But what's very nice about how the Davis-Sterling is engineered is there is a platform that really allows homeowners to, in a peaceful way, go to their association and air a grievance. And that's through IDR. So IDR stands for Informal Dispute Resolution.
Well, let's split those into two separate things, actually, because IDR we have actually as another point here. So I want to talk about just going informal, just talking to them, try to and to the extent that they
a precursor to IDR.
Precursor to IDR.
Oh, interesting.
You're trying to handle this without using the big words,
Okay,
right?
I hear what you're saying. So this is a little bit different. Okay, so when you said informal, I immediately jumped into IDR posturing. But before IDR, yes, that is having a conversation with the board, not making a demand for IDR, which we'll discuss.
Yes.
And this might be as simple as casually bringing it up with a board member,
Right.
casually, or even going to an open meeting
Yep.
and having a very calm, collected conversation about an issue.
Yeah.
That is maybe a perfect first step.
Yeah. Because hopefully your board is reasonable and hopefully reasonable enough to hear your grievances and make and you've documented well and you're well taken care of, so you're ready to approach them with some sort of firepower, but you can do it in a very peaceful way where they want to potentially work with you.
Yeah, one of the biggest issues I see, so when this works, it works and I never hear about it, so
Yeah.
I'm sure it works, right?
Yeah, I'm sure it works frequently.
When it doesn't work, normally the feedback I get from upset homeowners who are rightfully upset is they try to go to a meeting, they try to bring a grievance to the board's attention, and they have a very small window to do so.
Mm.
And it might be complicated. There might be a lot to this issue, and 2 minutes, 3 minutes, whatever amount of time is insufficient to properly convey the problem to the board.
Mm.
So there's almost a communication barrier immediately. They're too constrained to actually develop the position.
What are your thoughts on just approaching a board member or board president and just say, or writing an email, just casually, just saying, hey,
I'm for it.
I've got this problem.
I'm for it because ultimately, if you can resolve things without sort of leveling up or ratcheting up aggression, I think that's a win.
Because I think in a lot of these cases, particularly dealing with tyrants or meddlers, I mean, the emotions start to get real hot and real
Correct.
quick. And you as a homeowner, that's hard. This is your home,
Right.
and you're trying to keep. It's hard not to bust out of the ceiling, right? You want to try to keep those emotions in check as much as possible to get some sort of resolution. The minute you start throwing everything at the wall and fire comes out of your ears is when it goes nuclear, and it's not usually going to go anywhere.
If we're discussing a precursor approach, which is what we're doing,
Yes.
Strategically, what I would recommend is if you're going to write an email, it needs to be clinical. It needs to be objective.
Mm.
It needs to be, I've observed a water intrusion event. It appears to be from a common area pipe. This is impacting my property. I would like the opportunity to discuss in greater detail.
Mm.
Or, I've received this fine. It appears to be an error. Let's discuss.
Yeah.
Because as soon as you take it outside of the realm of clinical or factual, and you start to incorporate, emotionally charged words, and rightfully so, because you're upset. This is a horrible situation, and I get that part of it.
Yeah.
But because you're dealing with humans on the other side, it may not be useful if you're trying to resolve it.
Yeah, they might go instantly. Once you come at them with fire, they're going to instantly go defensive.
Circle the wagon immediately.
Yeah.
As opposed to them seeing, this seems to be an issue we can solve collaboratively, versus someone, they feel under attack, and then it becomes this whole thing.
Yeah.
So if you're going to go the precursor route, be objective, be clinical. It might be hard because you're rightfully very upset at a bad HOA, so I can empathize with that. But it might actually have a higher utility by presenting it in that way.
Sure. Now, to the extent that they ghost you, so there's a couple scenarios. You send an email, they don't do anything,
Okay.
or they send you an email and say go kick rocks,
Yep.
or you're not getting anywhere. But I guess a good situation is they're just not listening to you. They're ghosting you.
You're
one's
being
taking
ignored.
You're being ignored. The next step is you can ratchet this up with some sort of legalese and some sort of legal teeth in
Right.
there, which is IDR, which we started to briefly talk about. But I think that would be and correct me if I'm wrong, that's the next step. After you've been ghosted, after they're not working with you, no one's hearing you out. Now it's time to maybe ratchet it up and put a little bit of legal teeth in it.
Yeah, and let me back out a little bit, because what we're presenting here assumes certain things. It assumes that you haven't identified any problems necessarily within the association. It's not an association made up of 5 tyrants, right? I mean, if you know that the people on the board are going to stonewall you, or they're going to fight, or they're bombastic, or they're just horrible humans,
Yeah.
these steps may not be appropriate. You may want to save yourself the headache and just jump into lawyer land. You may want to start with an advocate.
Yeah.
Because why subject yourself to that sort of torture if you don't have to?
Sure.
But in this scenario, what we're discussing is typically maybe you don't know enough about the board to draw that assessment, or from what you've observed, it seems like it's functioning, but there's a problem with the board. So this is a reasonable approach, assuming that you don't have any indication that on the other side it's a dumpster fire. Does that make sense?
Yeah, it does. Although, would you not say if you've taken these steps, you're acting in good faith, and isn't that good? And isn't that a good fact pattern to have?
It can be a very good narrative, especially if this gets in front of a mediator, for example,
Right.
or a jury.
Yeah.
You can show, hey, I did this step, and that step, and I tried to work with them. I started with an olive branch.
Yeah.
But I guess what I've seen is some really bad situations where clients have extended an olive branch and their hand got chopped off. So I'm trying to, if it's a really bad emotionally charged situation, you may want to avoid the headache. That's all I'm saying.
Yeah.
And that avoidance or circumvention of these steps can always be articulated, in some fashion down the road.
Yeah.
You can show, hey, I would have operated in good faith. I would have done these things, but for this tyrant who said verbally, or who's yelled at me historically, or verbally, or has assaulted me, or whatever the case might be.
But that's good to the extent that happens. Document it.
Well, that's good ammunition, of course.
Yeah, but at least if a board member is making your life living hell, start documenting it right away.
Absolutely.
So even if you split off and say, I'm not going to do any of these because I don't want to be subjected to this sort of abuse, at least you have a narrative. At least you have got documentation showing and a timeline. This is why I split off and I didn't act in good faith.
Precisely. So that goes back to the first tip. But yes, document. But now, assuming you think that this, so the first attempt, the precursor, didn't work for whatever reason. Maybe they were ignored. So
let's just assume they've been ghosted. You're not getting anywhere. I tried reaching out. No one's answering my emails or phone calls or whatever.
So next step would be IDR. And IDR, again, is informal dispute resolution. It exists within the Davis-Sterling Act.
Under California law.
And the spirit there was really to have homeowners and boards come together without lawyers. Now, interestingly enough, I've seen situations where the board will bring a lawyer. I don't think necessarily in a negative way, but maybe just to help facilitate a resolution.
Oh, they're acting as the adult in the room to some extent.
Maybe, but the majority of time what happens is once you prepare a written notification, typically an email, and in the subject it's, a request for informal dispute resolution.
Yeah.
And that's sent over to the board. Well-functioning boards will accept it, acknowledge it, and get something on the books.
Yeah.
Now, the question is often, well, what if they don't? There's no real ramification legally, meaning there's no punitive damages, or there's no sort of punishment that they would receive other than the bad faith optics of it, because now you're establishing a sort of a history of bad faith.
Sure. Is it fair? Is it a fair statement to say that they're breaking the law at that point? But there's no consequence to that, because in the Davis-Sterling Act it says, IDR. This is what IDR is meant for. It's in the realm of the law. To the extent that they do not do that, they're not acting within the law. But there's no consequences to it.
Yeah. Well, typically how I would approach that in terms of a narrative is, the client in good faith requested IDR. Here's the request, and in seeming bad faith, the HOA said kick rocks.
Yeah.
Or ignored it. That's just bad.
Yeah.
That's just that is where there's smoke, there's fire. I mean, a good HOA will accept that.
Or even I would assume even a poorly managed HOA, even if they put that in front of their lawyer. Now, you can elevate speech. We talked a little bit about, in previous episodes, elevate the vocabulary because it shows that you mean business and you're sophisticated or educated enough to where they should probably listen.
Well, yes, a lot of our show is geared towards empowerment, and empowerment typically is driven by an elevated lexicon.
Yes.
Right? If you can step up the vocabulary, that can be a very powerful tool against a bad association because it gets their attention.
Yeah.
It's one thing to say to an association, "You're making my life a living hell." Typically, that's the case. But it is an elevated approach to say, you've violated the CC&Rs, Section 212,
Yep.
by failing to maintain a common area, and you are in breach of contract.
Yeah.
Or you're, at this point, this is a breach of fiduciary. You owe me a fiduciary, and by failing to do A, B, C, D, and E, you're in breach of your fiduciary obligations to me.
Yeah.
That is a very elevated way of approaching a dispute.
And if you're bringing an IDR and your vocabulary is elevated, and you say, "I'm requesting informal dispute resolution," brackets IDR within the Davis Sterling Act, California, and because in my opinion, you're in violation of CC&R X, Y, and Z. When can we get this on the date? I would assume even a non-sophisticated or somewhat ignorant, somewhat incompetent board member sees this, it raises the eyebrow, and maybe at minimum, they send it to their lawyer.
I think that's a fair bet because you've put enough in there where, in the eyes of a reasonable or even somewhat reasonable person, it's something's going on there, and it seems, it seems dangerous.
Yeah.
In some ways. As opposed to a letter that just rants and raves about a situation.
Sure.
Because you got to remember too, however what you draft is going to be analyzed not just by the board, but likely by a lawyer.
Sure.
And if you have a legit dispute, you do not want to muddy those waters with a bunch of emotionally charged ranting and raving.
Yeah.
And again, I go back to this. I understand why homeowners do it because this is so frustrating to them. This is where they live.
Yeah.
It is an absolute hell for them.
Yeah.
And I get that. But don't shoot yourself in the foot. Take away the emotion. You got to compartmentalize it to the best that you can. It's hard.
Yeah.
What I would recommend is write the IDR, on day one, and then on day two, go back to it and read it. And
that's
try to
a great idea.
Yeah. Get all the venom out and then, sort of cleanse it the next day.
ChatGPT, can you make this sound like I'm not emotionally
sure,
unstable?
Use AI. Right. And typically, you talk about emotional instability. We deal with, individuals who are successful, businessmen and women who are, CEOs of massive companies. And because they're in such a bad situation with their HOA, they're just losing it, rightfully. And these are individuals with tremendous mental fortitude.
Yeah.
Just sharp, wicked, intelligent, very well-heeled educationally.
Yeah.
And even for these individuals who you would think who could, withstand a tremendous amount of pressure, they're losing their minds over this.
Yeah.
Because it's such a visceral situation.
Yeah.
When you have a bad HOA, it infects all areas of life. And it drives people crazy, right?
This is your safe. Supposed to be your safe place.
It's supposed to be, and then you have this rogue group that is just making your life a living hell.
Yeah.
So I get it, but that all being said, try to take that out of the written communication.
Yeah,
because that's how you're going to be judged.
Yeah, that's another good tip. Okay, let's assume that they ignore you for IDR, or they say some response that you're not getting anywhere.
Right.
At this point, would you say it's time for a lawyer? Like we've exhausted most of the options here.
I would say at that point you consult with a lawyer.
Yeah.
And always best, in my opinion, and this is objectively. I know we're a law firm that really focuses on HOA. We're homeowner driven.
Yeah.
But you really want to find a lawyer who's well versed in this space.
Yeah.
And there's a big difference between an HOA attorney who represents homeowners and a general real estate attorney.
Sure.
Because the area of law in homeowner association is fairly complex. You have a lot of different competing areas of law. I mean, you have state, federal,
Yeah.
right, local.
Yeah.
You have CC&Rs, you have bylaws, you have Davis Sterling, you have fiduciary, you have case law interpreting it all.
Yeah.
So it is actually a very niche area of the law. So if you're going to find a lawyer, my first recommendation is find someone who really is knowledgeable in the space.
Yeah.
And if you're a homeowner, I tend to recommend law firms that only represent one side, meaning homeowners. I don't necessarily agree with someone who represents HOAs and homeowners. I think you pick a side.
Yeah.
You can't be on both sides of this coin, in my humble opinion on that. And, a lot of attorneys, you see different setups for consultations. I think a good consultation is probably an hour.
Yeah.
You have some law firms that charge for the hour, and you have some law firms that offer free consultations.
Yeah.
So I would call around. You want to be comfortable with, the law firm. I always say go online, check the reviews, see what the public is saying.
Yeah.
And ensure that they have some sort of thought leadership in the space.
Yeah.
And, at that point, you're going to at least spend an hour with a lawyer.
Yeah.
To kind of have that lawyer look at it. Again, the lawyer should come in more objectively and really at that point sort of analyze both the legal and economic side of the equation.
And I mean, there's plenty of cases that you see where they just need the consultation to give them some guidance to get to that next step. It's not a predestined thing that they're going to end up, in front of a jury or in front of a mediator, or
Right.
There's lots of aspects there.
Well, that's where I think a dynamic attorney comes in, because an attorney who can analyze a situation and say, okay, you have 4 options. Here's the option. If you want to engage in self-help, this is what it looks like. And that attorney will draft the blueprint.
Yeah.
Or if you want attorney intervention, this is what it could look like on this flow. This is what it could look like if we tackle it this way.
Yeah.
And really, there should be a number of options, because most attorneys who are dynamic can identify different ways to approach the problem.
Yeah.
With that, though, they should always give the pros and cons.
Sure.
Because there's an up and a down of any strategy that you implement. There's going to be pros and there's going to be cons, and you got to know both.
And I assume a lot of that comes down to the economics of it. There's probably times that there's no damages, but your life's just living hell. What's it going to take to try to reverse course on that? Versus there are damages. There's $100,000 worth of damage that is caused by your HOA. There's something, tangible there. So there's an economic factor there too when it comes to probably strategies. Even.
Yeah, economics always ties into it. Legal strategy, of course. What does the evidence look like? How strong is the case? What is the makeup of the board? Who's on the other side of it? Who is, the association's counsel?
Yeah.
There's a lot of things you have to read to make informed decision. The more data you have, the better. But hopefully during that consultation, you have enough data to put together some pretty good strategies.
Yeah.
But also, analyzing the economics of it, the legal side of it, and hopefully between the lawyer and yourself, you come up with something that makes good business sense.
Sure.
Because ultimately, you as the homeowner, it's your decision as to how you want to move forward.
Yeah.
There shouldn't really be a sell, so to speak, from the attorney.
Sure.
It should be a somewhat of a, hey, here are your 4 options. Here are the pros and cons of those options. Now you as homeowner make the business decision.
Yeah.
And, with any option, and I've been in the space now for a very long time, there's really no silver bullet.
Yeah.
There's no magic wand necessarily.
Yeah.
This is advocacy, and it's fighting against another side. It is a form of war. And so there's unknown risk in war.
Yeah. Let's just really quick talk about, if you do need to see an attorney, what would you advise a listener if they're at this point where I'm considering attorney? What should they prepare? What should they have in front of them? Because I know there's information overload, and there's no possible way, if you dump hundreds of pages worth of X, Y, and Z onto an attorney, they're not going to be able to get through that in an hour consultation. What is the ideal amount of preparation for that attorney so you make that consultation as seamless as possible to get the most out of it and to set yourself up for a good working relationship?
Yeah, so you're looking like at the Goldilocks scenario, because on the one hand, you don't want to show up with nothing.
Yeah.
That's not helpful. And you also don't want to be the person who shows up with 7 banker boxes of documents. that's not helpful either.
Yeah.
So where's the sweet spot on that? So my recommendation, first and foremost, is to do some work before the consult. And one of the best things I find very helpful is create a timeline or the background allegations. It doesn't have to be perfect. And you don't want to muddy it with too much information, but what were the highlights? What happened on this date? What happened on this date? What happened on this date?
The most egregious offenses.
Correct. And, if you can sort of map that out and in that document put who are the players, who are we dealing with, and then articulate with some sort of specificity, what is your objective? What are you looking to accomplish here?
That's interesting.
That is very helpful because, a lawyer approaching a consult really should start with your objectives. Because if you start with the facts, that could take 3 hours. Because typically these disputes have have accrued over years, some of them. And so by honing in on the objectives of the homeowner, this is what you want to accomplish, the lawyer will be in a better position to understand, okay, how does the fact slot into this objective? And they'll be able to triangulate a little bit better and understand the not reasonableness, how relative the facts are to what you're pursuing.
Yeah.
And that's very important.
Would you recommend, obviously at some point you're probably going to need to see the CC&R. Should they have those handy for the consultation and possibly the areas that if they've gone through it according to our steps, they should know the areas that they've potentially violated. So was that helpful as well?
So start with the outline, with the objectives, and map that out.
Yeah.
Part 2, governing documents, of course.
Yeah.
Very helpful. Part 3, relevant communications with the board, emails back and forth. I think that can be very helpful because that's going to give the attorney a little bit of a flavor of who we're dealing with.
Sure.
4, if you have video or pictures. Now, don't send 10,000 photos, but I would curate those.
The most relevant.
Absolutely. And then maybe if you have an expert report, you sort of back into, these different things. You start with I think that the starting point is always going to be that outline.
Yeah.
Right. That's good. Then if you have them available, governing docs.
Sure.
And then if you have back and forth, then do the emails. Right.
Yeah.
And sort of, you should, and even better if you can put it in one folder or a binder. That's always well received. But if not, I think it's fine just to upload them separately if it's a remote consult.
Yeah.
But if it's in person, just bring a binder. You have a binder, give the binder to the attorney, and just you guys can walk it through together.
Yeah.
I think that would be the best use of that hour or so of the consult time.
Perfect. Well, I think we covered all the bases here. And I think, again, we just covered the very surface level on this thing. And we've gotten into so much more detail on very specific dispute types. Again, failure to repair, harassment, common area disputes, negligence, CC&R, neighbor disputes, selective enforcement. We have full episodes that are nearly an hour long on each one of those that outline, okay, who are you dealing with, how to approach it, collecting evidence, and how to deal with it that are really helpful, as well as the personalities of board members.
Yep.
I think that if you're interested in looking at and diving deeper, those episodes are great. Like I said, they're chock full of information. But I think this has been really helpful. I think it's great.
No, I love this. This is all you, Marty. You came up with this, but it was a really nice way to take out the framework.
Yeah.
I mean, this episode, as I see it, as we're doing it in real time, is really the framework in which to enforce. And then I suppose everything else that we've done so far sort of gives it context.
Yeah.
So thank you for making this happen.
Always a pleasure. I'm glad to be a part of it. It's interesting. It's fun.
All right. Well, thank you guys for watching. Hopefully we have been a resource, and don't forget to subscribe. And again, leave comments. If you have questions, concerns, we can hopefully address those on future episodes.
Yeah. Or if there's any episodes that you want to hear about specifically that we haven't already covered, even though we've covered quite a bit. I mean, it's always great to get some feedback and potentially gather some new ideas for new episodes.
Very good. All right. Well, thank you guys, and we'll see you soon.